Unfortunately, the WTM order, not the documents reflecting service of such WTM order, was exhibited by the Learned Counsel. Only take it up from page 86. Millard, it starts with that cross-examination on behalf of accused number 3 on 23/3/2022.
Yes.
Cross-examination on behalf of accused number 3. We have served notice on accused 2 to 4 for personal hearing, but they did not appear before us. We have not submitted any documents before the court to show that they had received the notice. Millard, in view of those facts, we filed the application before the learned magistrate, that learned judge, that is at page 95.
Ninety?
Millard, 95.
Yes.
Millard, paragraph 3 and 4. And then kindly seize the order. সেগুলো দেখাবো। লিমিট আছে সব। Your lordship has seen the order.
Yes.
Now, what are the reasons? The reasons are that you have not served those copies before. This is, Milord, if your lordship kindly takes up the second page
Second page upon hearing
of the order.
I find that the prosecution
Upon hearing both sides and upon perusal of the material, I find that though the prosecution has stated that these documents are very much needed and vital for arriving at a just decision in this case, yet no such document has been annexed to the petition by the prosecution, and neither have copies of the said documents being served on the defense prior to adducing of evidence or even argument of this case. My lord, can I do it by serving it before the argument of the case? Does it serve any purpose? Unless the permission is given, can I hand over those documents to them? Then kindly sees, if these documents were indeed vital to the prosecution, then the said documents should have accompanied the complaint petition and copy should have been given to the defense. From the evidence of PW1, I find that PW1 has merely mentioned that such documents have not been filed before the court, but no explanation has been given for non-filing of the same. There is only a vague mention that notices have been served on the defense. Going through the entire facts and circumstances of as above, I do not find any cogent reason for which the prosecution may be allowed to bring the said documents before the court at this stage. In fact, the entire matter appears to be an afterthought of the prosecution. Now, if I may take your lordship to section 311. May I place it? Any court may, at any stage of any inquiry, trial, or other proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined. And the court shall summon and examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case. Now, what has been my conduct, whether it's an afterthought, all these are not relevant considerations before the court. What the learned court was required to do was to find whether this evidence appears to it to be essential to the just decision of the case. Well, the impugned order does not address that issue. It says if the prosecution thinks it is required for the essential for the just decision of the case, then it should have done this, done that, whatever. But the learned court was to come to a finding that it is essential to the just decision of the case, or it is not essential to the just decision of the case. If the learned judge found that it was not essential, he could have rejected my prayer. That's a different issue. If he had found it to be essential for the just decision of the case, then he should have allowed it. But there must be a finding as to whether it is essential or non-essential. In the entire order, there is no such finding, that I do not find it to be essential. And with great respect, the learned judge says that it's an afterthought. That is the other ground. Well, it was mentioned in the petition of complaint. An afterthought or a filling up of a lacuna in the prosecution cases where it is not mentioned anywhere and is being brought in for the first moment.
Yes.
Now, therefore, my first submission is that this order is a product of non-consideration of the essential requirements of this petition filed by the SEBI. The essential requirement was whether it was essential for the just decision of the case. That issue itself has not been addressed by the learned judge. The learned judge, in his wisdom, has dealt with other issues. Said, if the prosecution thought it was essential, why didn't he do so? It should have served upon the defense earlier, or it should have accompanied the petition of complaint. Well, that is not the issue which fell for consideration before the learned judge. The issue which fell for consideration before the learned judge was whether these documents, that is the order of the whole-time member of the SEBI, and second, the documents reflecting service of such order upon the accused persons, were essential to be brought on record, or were essential evidences which were required for the just decision of the case. And if the learned judge finds that it was essential, then he had no other option but to grant that relief under 311, because the word is shall and shall. Now, therefore, and now coming to why it is essential, let me try to satisfy your lordship from the facts of the case. There are two aspects of this case. First is the issuance of the public issue without compliance of the statutory requirements. That is one part of the prosecution's case. The other part is non-compliance of the order. What did the WTM pass? He passed an order asking them to wind up those schemes that they had opened and to refund the money which they have collected. Now, that is also an essential order required for the purposes of protecting the interest of those investors who have been duped by this company. Now, he has not complied with the same. Now, in order to show his non-compliance, I am required to show that he had knowledge. And that is why in our petition of complaint, At paragraph 16, we had said that despite service of that order, he did not comply with the same. And therefore, those documents are required to be brought on record as evidence in order to show his deliberate non-compliance of the order of the WTM. And therefore, it is a document which is essential to the just decision of the case. So that's why, with great humility, I submit that first of all, the order of the learned magistrate is perverse on the ground of non-consideration of essential requirements of section 311. The second issue is that the learned judge says that it was an afterthought. From the petition of complaint, I have shown to your lordship that it is not an afterthought. It was there in the petition of complaint. Due to inadvertence, it was not brought in the evidence. An error on the part of the learned counsel to put those questions, to bring on record those documents, cannot divert the course of justice to the benefit of the accused. He is entitled to the relief if it is shown that it was never mentioned. It was never there on record and it is being brought on for the first time. Then there is a question of filling up the lacuna in the prosecution case, which the Honorable Supreme Court has said no. 311 cannot be used to fill up the lacuna in the prosecution's case. And how has the Honorable Supreme Court defined that? That it was never there and it is being brought for the first time. But in this case, it is not being brought for the first time. It is there in the petition of complaint. It was not translated into evidence by bringing on record those documents and is an error. Now, whether by commission of an error, a party can be denuded of his right to bring it on record to the detriment of the interest of justice. My humble submission is that it is for these purpose that section 311 has been brought on record. In support of my contention, I would only place the following three judgments. Hey. I'll be handing over the judgments with the Mannan Shekhta Kunta. Sheta Dao, Patil, Varshagar. I have given the paragraphs. They all deal with the second part of 311, which says that if it is found that the evidence to be brought on record is essential to the cause of justice, then there is no other course left to the court but to issue or recall and re-examine the witness or bring on record the documents through that witness. We have also annexed the relevant documents that we want to bring on record. That the whole time members order is at page 16 of our petition.
Page 60.
Page 60, my lord can see.
0.
Oh, that is sorry. That's page 49. I'm sorry, my lord. I'm extremely sorry, my lord. Page 49 and the relevant order, the relevant part is at page 61. How is that? That order looks equal, sir. So these were the directions. I'm sorry, page 60, 10.2. Page 60, 10.2. This was the direction which was given to them, which they failed to comply.
60.
60, my lord. 10.2.
So that one, it starts from
My lord, it starts from
49.
page 49, yes. And page 60 is the final direction.
60. Yes. Shall come into force with immediate effect. Uh, 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 It is WTM order.
Yes, my lord. The order that we want to bring on record, and page 63 to 68 are the documents relating to the service of that order upon the accused persons. These are the documents we want to bring on record. My lord, only may I have a humble prayer?
49 to
49 to 68. Section 27 take to the queue. No, 27 now.
yes.
Yes. Millard, therefore, in those circumstances, Millard, I have a humble prayer. Millard, would your lordship permit my learned junior to place the relevant parts of those judgments before your lordship? Millard, I'll just come back. I'm deep.
Yes.
Judgment, place for according to that.
No, Millard.
Yes. First,
Millard, the first judgment, Millard, we'll be relying upon to show that Manan Sheikh, Millard.
Manan Sheikh, yes.
Millard, 2014-13 SCC 559. Millard, the relevant paras which we'll be relying upon, Millard, is 12, 13, 14, 15, and 22. Millard. Millard, just to give a brief history, Millard, Millard, I'll be placing from para 2, Millard. Para 2, Millard, just to point out how was the case starting, Millard. A petty altercation over a tape recorder resulted in a major incident in which bombs were hurled at Roopchand Sheikh, the father of PW8 Nurul Islam. The incident occurred on 13th of December 1992. Roopchand Sheikh suffered grievous injuries. He was taken to the local hospital. From there, he was shifted to Behrampur, where he breathed his last breath. Now, Millard, thereafter, Millard, FIR was lodged. It says in para 3. In paragraph 4, Millard, it says that after charges were framed, the trial began. PW15, SI Dayal Mukherjee, investigating officer, was examined on Itna. He was re-examined on 17th of May 2011. he stated in his evidence that he had recorded deceased Rupchand Sheikh's statement at the scene of the offense. In the cross-examination, he stated that he had recorded one-page statement of the deceased Rupchand Sheikh. His statement was not brought on record, Miller. This was the contention, Miller, that his statement that the investigating officer had recorded, that was not brought on record by the prosecution during the evidence of PW15. 1 month thereafter, on 16th of June 2011, the prosecution moved an application for recalling PW15 SI Dayal Mukherjee because the prosecution wanted to bring on record the statement of the deceased Rupchand Sheikh, which it had inadvertently omitted to do so. Needless to say, it is the prosecution's case that after the death of Rupchand Sheikh, the statement became his dying declaration, Miller. So, Miller, this was similar to our case. This is what had happened in Manan Sheikh, that a dying declaration inadvertently, due to the lacuna of the prosecution, could not be brought on record, and therefore a 311 petition was moved to re-examine the witness and bring that document on record, Miller. Now, Miller, the observation of trial court is at page 6, paragraph 6. The trial court, video order dated 22nd of June 2011, rejected the said application. The trial court observed that the case was at the stage of argument, similar to our case, and no explanation was given by the prosecution as to why the statement of the deceased Rupchand Sheikh was not brought on record by the investigating officer. The trial court noted that PW15 SI Dayal Sheikh was examined on 18 of February 2000. The prosecution is allowed to recall SI Dayal Mukherjee, so PW15 SI Dayal Mukherjee, it would enable the prosecution to fill up the lacuna. The trial court relied upon State of Rajasthan with Daulatram. This is the judgment. The trial court observed that re-examination of PW15 is not essential to the just decision of the case. Being agreed, Miller, they moved before the High Court, Miller. The High Court also rejected the prayer for 311, Miller. Now, Millard, what comes to paragraph 12, Millard, subsequently the arguments of the counsels before the Supreme Court is recorded. Millard, the relevant para starts now at paragraph 12, Millard. So, Millard, that was the brief history, and now, Millard, this is what the Supreme Court is observing. The aim of every court is to discover truth. 311 of the code is one of the many such provisions of the court which strengthens the arm of the court in its effort to ferret out the truth by the prosecution sanctioned by law. It is couched in very wide terms. It empowers the court at any stage of any inquiry, trial, or other proceedings under this code to summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine already examined witnesses. Now, Millard, kindly observe, Millard, kindly notes this, Millard, from here. The second part of the section uses the word shall. It says that the court shall summon and examine or recall or re-examine any such person in his evidence if his evidence appears to it to be essential to the just decision of the case. The words essential to the just decision of the case are the key words. The court must form an opinion that for the just decision of the case, recall or re-examination of a witness is necessary. Since the power is wide, its exercise has to be done with circumspection. It is tried that wider the power, greater is the responsibility on the court which exercises it. The exercise of this power cannot be untrammeled and arbitrary, but must be guided only by the object of arriving at a just decision of the case. It should not cause prejudice to the accused. It should not permit the prosecution to fill up the lacuna. Whether recall of a witness is filling up of a lacuna or is just decision of a case depends upon the facts and circumstances of each cases. In all cases, it is likely to be argued that the prosecution is trying to fill up the lacuna because the line of demarcation is very thin. It is for the court to decide all circumstances and decide whether the prayer for recall is genuine. So, Millard, this was the observation, Millard. The parameters on which 311 has to be looked into, Millard. Now, my lord, paragraph 13, my lord, rather than referring to all the judgments which are cited before us, we would concentrate on Mohanlal Soni, which takes into consideration relevant judgments on the scope of section 311 and lays down the principles. Mohanlal Soni is followed in subsequent judgments. In Mohanlal Soni, this court had considered the scope of section 540 of the Criminal Procedure Code, that is the old code, which is similar to section 311 of the code. This court observed that it is the cardinal rule in law of evidence that best available evidence should be brought before the court to prove the facts and the points in issue. The relevant observation of this court are as under. I'm referring to that. Those observations which have taken place in Mohanlal Soni, Millard. In order to enable the court to find out the truth and render a just decision, the salutary provision of section 540 of the Criminal Procedure Code or section 311 of the new code are enacted, whereunder any court, by exercising its discretionary power at any stage of inquiry, trial, or other proceeding, can summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any person in attendance, though not summoned as a witness, or recall or re-examine any person already examined, who are expected to be able to throw light on the matters in dispute, because if the judgment happens to be rendered on incoherent, inconclusive, and speculative presentation of facts, the ends of justice would be defeated. Now, Millard, subsequently, and again, Millard, it was there, Millard, the next paragraph, that is para 18 under para 13, Millard, that just and fair decision has to be taken into consideration, Millard, as it was placed before. Now, Millard, the emphasis has been relied upon in this judgment is at page 66, Millard, that's the next page. Millard, this is relevant to the instant case as well. Millard, may I place this? Has the lordship gotten? Millard, page 66, Millard. The first paragraph itself.
Page
66, Millard. Millard, it's at the top left, Millard, the page numberings, Millard.
Yes, yes.
Millard, may I place the paragraph?
Got it.
Millard, therefore, it should be borne in mind that the aid of the section should be invoked only with the object of discovering relevant facts or obtaining proper proof of such facts for a just decision of the case, and it must be used judiciously and not capriciously or arbitrarily, because any improper or capricious exercise of the power may lead to undesirable results. Further, it is incumbent that due care should be taken by the court while exercising the power under this section, and it should not be used for filling up the left by the prosecution or by the defense, or to the disadvantage of the accused, or cause serious prejudice to the defense of the accused, or to give an unfair advantage to the rival side. And further, additional evidence should not be received as disguise as retrial or change in nature of the case against either of the parties, Millard.
Honorable application in para 12.
Millard.
It's founded with value regarding essentiality of section 311. Next
Millard.
case.
Now, Millard, paragraph. Millard, next case I'll go, Millard, but Millard, just to place Millard, paragraph 22, Millard. Millard,
22.
after Millard of this judgment, Millard, this is
Oversight was deprecated by the Honorable Apex Court. Oversight of the
Millard, this paragraph 22 is actually relevant, Millard, because what had happened in this case is, Millard, despite a witness being examined, again called for re-examination, he was called for further re-examination for a second time to place a dying declaration.
Only it is to be decided.
Millard.
That prosecution is trying to fill up the lacuna. Court has enormous power. Even can of his own can invoke section 165 of the Evidence Act.
Millard.
Produce the documents if it is required for the just decision of this case.
Millard.
So court has enormous power.
Millard.
No problem.
Millard.
But only court is to find out whether fill up lacuna or not.
Millet,
Fill
I,
up lacuna, it is very thin, Honorable Apex Court.
Millet, I bowed.
Line between the just decision of the case and fill up lacuna, very
Millet.
thin line. It has to be decided by the court,
Millet,
whether it requires for the just decision of the court or for filling up the lacuna.
Millet,
This has to be adjusted by
Millet.
balancing.
Millet. For that reason, Millet, I place the
That
judgment is
that
for
is the main issue.
main issue.
That
Millet,
the court has enormous power
Millet,
to
it
recall
has.
any witness, to ask for production of any document,
Millet.
but for just decision of the case.
Now, Millet, what would amount to filling up of a lacuna? Is what filling up of a lacuna means something coming to the light
For the first time.
subsequently for the first time
For the first.
when the defense has been taken.
Lacuna has to be also has to be
Looked in-
adjudicated from that point of
That
view.
point of view,
whether-
what is the
whether
lacuna?
it was never came before the court, never cited, never explained,
Miller.
nothing explained.
Or it was a mere inadvertence on the
According
part
to
of
you, it is in the
petition of complaint itself.
petition of complaint, as well as during cross-examination also.
You have
it was-
stated, but we had failed to bring those on record. Now, Millet, I'll just place
Yeah,
paragraph 22
cross-examination, this oversight was
discovered.
came-
Millet, and Millet will kindly read, Millet, this is very important, paragraph 22. Millet, after going through all the judgments in the lights and circumstances of the instant case, Millet, the Supreme Court held, in the ultimate analysis, we must record that the impugn order merits no interference. Millet, since the High Court had allowed 311, we must, however, clarify that oversight of the prosecution is not appreciated by us, but cause of justice must not be allowed to suffer because of an oversight of the prosecution.
Inadvertent mistake was found in the part on the part of the prosecution.
Miller.
The Honorable Apex Court. Therefore, such oversight was not appreciated by the Honorable Apex Court.
Well, similar is our
Be
case. Millet.
cautious. Just this and warning, be cautious about
Millet.
production of the
Millet.
vital documents.
Similar is our case, Millet. Millet.
Next.
Millet, then Millet, I'll be relying upon VN Palit versus K Niranjan Kumar, Millet, 2000.
Patil. VN Patil.
Patil.
Yes.
Paliti Baba. VN Patil versus VK Niranjan Kumar, 2021-3, SCC 661. Millet, the relevant paras are 10, 14, 16, 17, and 21. Millet.
Yes.
No, Millet will just looks at the facts of this case, Millet. Paragraph 2, Millet, during the pendency of the trial, an application was filed by the learned special prosecutor under section 173(5), read with section 311 of the Code of Criminal Procedure for summoning a witness along with securing relevant records to meet the ends of justice. The learned additional city civil and sessions judge, Bangalore City, after detailed discussions and taking note of the scope of section 311, allowed the application by order dated 3/9/2016 after assigning cogent reason in support thereof. This came to be challenged by respondent number 123 in the petition filed under section 482. The learned judge of the High Court, after recording submissions made by the learned counsel for the parties without assigning any reasons, albeit brief, which may at least facilitate this court to understand what weighed with the judge in setting aside the findings recorded by the learned trial court in its order dated itna by impugned order and judgment. They were set aside. Aggrieved by the order of the Honorable High Court, impugned order dated 1st of January 2011, the appellant complainant, that is the father of DC, approached this court by way of a special leave. The backgrounds in brief, which may be relevant for the purposes, are that the marriage of Keethi, the deceased daughter of the appellant, was solemnized with the first respondent on this date. On the intervening night of this date, at about 3:30 a.m., the appellant received a call that her daughter had died in connection with her unnatural death. On the basis of a complaint filed by the appellant, this case was registered at Sanjay Nagar Police Station, Bangalore, for offences punishable under 302 and 498A. During the course of the trial, as per the records and evidence, the examination of all the relative witnesses and the documentary evidence produced by the investigating officer indicated that the second postmortem of the victims body was conducted on this date by a team of 5 doctors in JJ Hospital, Mumbai, in respect of which the investigating officer PW54 had corresponded with exhibit P140 to 142 seeking for the copy of the said second post-mortem examination on 13th of September 2005 itself. It further reveals that the stated document indicated above was not made available to the investigating officer during the submission of the main charge sheet and the additional charge sheet. The learned trial court had permitted to produce the document by its order dated 30th of October 2012. Even after exhibit P142, the original document of the second post-mortem with other relevant documents was still with the Mumbai doctors and police, and PW27, Dr. Bhimappa Havagnur was conducted, who conducted the first post-mortem on this date, turned hostile. At this stage, an application came to be filed by the learned additional special public prosecutor under section 173(5), read with 311, for summoning a witness and to examine the doctor who had conducted the second post-mortem examination to meet the ends of justice. The first PM doctor turned hostile. Second PM report was never brought on record. Therefore, a 311 application was moved to bring the second PM doctor on record and his observations in the PM report on record by the documents. Then Miller would kindly goes to straight to para 8, Miller. The learned trial court, after perusal of record and taking into consideration the rival contention of the parties, observed that the case is registered identically at Sanjay Nagar Police Station, Bangalore, under this case, which was later on investigated by the then Corps of Detectives, Bangalore, and thereafter the original charge sheet and the additional charge sheet was submitted, in which it was clear reference on record documentarily, as well as to a deposition of PW44, who stated to be the investigating officer. The record further revealed that the second post-mortem examination, which got conducted at JJ Hospital, Mumbai, appears to have been made through the Worldly Police, Mumbai, by lodging the complaint there and by the members of the family of the deceased. Wherefrom, at very outset, it is not the post-mortem record having made privately, as it is through the police at Mumbai, Millard. It was further observed that as per exhibit P136, 140, which were available on record, that PW44 investigating officer had initiated the correspondence with Worldly Police as well as the doctors of the JJ Hospital seeking for sending of the copy of the second post-mortem examination, which clearly indicated that there were that the very intendment prevailed with PW44 in corresponding with the Worldly Police Station, Mumbai, and the Mumbai doctors with exhibits P136 and 142 to obtain the said copy of the second post-mortem conducted at the JJ Hospital, Mumbai, required for investigation by him in Bangalore, by considering it as a part and parcel of his investigation, and the second post-mortem is not the outcome of the personal insistence of the family members of the deceased, but the relevance of the second post-mortem with the case which PW44 had deposed in his chief examination itself, more particularly in connection with exhibit P136 and P140 to 142. Taking note of the factual metrics of the matters on record, the learned trial judge, after assigning cogent reasons, allowed the application filed under section 311 to meet the ends of justice, observing further that no hardship or prejudice would be caused to the respondent accused, since the said witness and documents intended to be summoned will certainly be subjected to cross-examination and their testification as per the provisions of CRPC. The author of the trial court was assailed by this respondent under section 482. The High Court had not taken any pains at examining the scope and ambit of 311 and reasons assigned by the learned trial judge, and erroneously set aside the order of the learned trial judge by the impugned judgment. This, after going through the rival, then Millard, section 311 has been again founded. Yes. Now Millard comes to paragraph 14, where again 311 has been examined. The object underlying 311 is that there must not be a failure of justice on account of mistake of either parties in bringing the valuable evidence on record, or leaving ambiguity in the statement of the witnesses examined by either side. The determinative factor is whether it is essential for the just decision of the case. The significant expression that occurs is at any stage and inquiry or trial or other proceedings under this case. It is, however, to be borne in mind that the discretionary power conferred under 311 CRPC has to be exercised judiciously, as it is always said that the wider the power, greater is the necessity of caution while exercising the judicious discretion. Now, Millard, paragraph 16, Millard, again, Millard, certain judgments of the Supreme Court have been relied upon, wherein relevant observations are, Millard, they have explained how second part of section 311 is mandatory, wherein first part is discretionary. Millard will kindly looks at this paragraph 16, Millard, the subpart 10. The first part of this section, which is permissive, gives purely discretionary authority to the criminal court and enables it at any stage of inquiry, trial, and proceeding under the code to act in one of the three ways, namely to summon any person as a witness, to examine any person in attendance, though not summoned as a witness, or to recall and re-examine any person already examined. This is important from here, Miller. The second part, which is mandatory, imposes an obligation on the court to summon and examine or recall or re-examine any such person if his evidence appears to be essential to the just decision of the case. Miller, we lie in the second portion, Miller. Recall or re-examine any witness if his evidence is necessary for the just and essential decision of the case, Miller. It is well settled that the power conferred under section 311 should not be invoked by the court only to meet the ends of justice. The power is to be exercised only for strong and valid. It should be exercised with great circumspection. The court has wide powers under this section to even recall and re-examine and further examination necessary in the interest of justice, but the same should be exercised after taking consideration the facts and circumstances of each case. The power under this provision shall not be exercised but if the court is of the view that the application has been filed as an abuse of process of the court. Now, Miller, the main aim, para 17, Miller, now, the main aim of every court is to discover the truth. Section 311 of CRPC is one such provision which strengthens the arm of a court in its effort to unearth the truth by procedure sanctioned by law. At the same time, the discretionary power vested under section 311 CRPC has to be exercised judiciously for strong and valid reason with caution and circumspection to meet the ends of justice. Now, Miller, these were the parameters. Taking into consideration further judgments, Miller, will kindly comes to paragraph 21 now. Miller, what was the finding in this case, Miller, where a doctor, PM doctor who was not examined and his statement and his documents of PM report were not exhibited. Now, Miller, what the Supreme Court held after considering all the facts and circumstances under 311. In the instant case, although the application was filed by the learned additional special public prosecutor under section 173(5), read with section 300, but it is open for the learned trial court as well as to exercise suo motu powers in summoning a witness whose statement ought to be recorded to subserve the cause of justice with the object of getting the evidence in aid of a just decision and to uphold the truth. Miller, this is a very important. Miller, I'll place it again. With the object of getting the evidence in aid of a just decision and to uphold the truth, Miller. These are the parameters. If an evidence has to be brought on record by 311, the parameter is to getting an evidence for the just decision and to uphold the truth, Miller. Now, Miller, thereafter, the petition was, the order of the High Court was set aside and the order of the learned trial court was upheld, and Miller, 311 petition was allowed. Miller, we also fall under the similar category wherein due to inadvertence, Miller, the prosecution SEBI authorities failed to bring on record the documents which evidence that an order of the whole time member has been served upon the accused person. Miller, 311 has been placed in the CRPC to overcome such, I would say, Miller, negligence or oversight of the prosecution. Miller, these cannot be looked into as filling up of lacuna of a court, filling up a lacuna during trial, Miller. When Supreme Court in the previous two judgments have placed, they have also looked into these facts and have allowed such 311 petitions, Now, the final judgment, of Varsha Garg.
Yes.
Now, the third and the final judgment, which I'll be relying upon, Varsha Garg versus State of Madhya Pradesh, 2022, SCC Online SC 986, The relevant paras are 32, 37, 42, 44, 45, 49, 50, 51, No, this is a detailed judgment, where there were a lot of applications that were moved before the Supreme Court, wherein 311 was first allowed. There were 311 petitions that were already kept pending. The facts may not be that relevant, It kindly comes to paragraph 32, where 311 has been explained by this court, Paragraph 32, This power, will kindly come to paragraph 31. Having clarified that the bar under 311 is inapplicable and that the appellant is well placed to pursue this appeal, we now examine 311 of CRPC. Section 311 provides that any court may summon any person as witness or to examine any person in attendance, though not summoned as a witness, and recall and re-examine any person who has already been examined. This power can be exercised at any stage of an inquiry, trial, and other proceedings under the CRPC. The latter part of Section 311 states that the court in courts shall summon and examine or recall and re-examine any such person if his evidence appears to the court to be essential to the just decision of the case. Section 311 contains a power under the court in broad terms. The statutory provision must be read purposefully to achieve the intent of the statute to aid in discovery of the truth, The first part of the statutory provision, which uses the expression in courts may, postulates that the power can be exercised at any stage of an inquiry, trial, or other proceedings. The latter part of the provision mandates recall of a witness by the court, as it uses the expression shall summon and examine or recall and re-examine such person in his evidence appears to it to be essential to the just decision of the case. Essentiality of the evidence of the person who is to be examined, coupled with the need to just decision of the case, constitutes the touchstone which must guide the decision of a court. The first part of the statutory provision discretionary, while the latter part is obligatory. We fall in the latter part, which is obligatory, and the touchstone which has to be guided under 311 is the decision has to be for the fair and just decision of a case. The evidence has to be for the just and fair decision of a case. Now, again, as in Manan Sheikh, Mohanlal Soni, it's quite a celebrated judgment, has again been relied upon, I'll not be placing it again, Now, will kindly comes to paragraph 36, summing up summing up the position as it obtained from various judgments of this court, namely this court, after taking into consideration all the 5-6 judgments that is referred herein, this court held that the principle of law that emerges from the view expressed by this court in the observed decision is that criminal courts have ample power to summon any person as a witness or recall and re-examine any such person if the evidence on both sides is closed, and the jurisdiction of the court must be obviously be dictated by exigencies of the situation, and fair play and good sense appears to be the only safeguards and the only other requirements of justice command the examination of any person, which would depend on the facts and circumstances of each case. Miller. Paragraph 37. The powers of the court is not constrained by the closure of the evidence. Therefore, it is amply clear from the above discussion that the broad powers under section 311 are to be governed by the requirement of justice. The power must be exercised whenever the court finds that any evidence is essential for the just decision of the case. The statutory provision goes to emphasize that the court is not a helpless bystander in the derailment of justice. Quite to the contrary, the court has a vital role to discharge in ensuring that the cause of discovering the truth as an aid in realization of the justice is manifest. Now, this is where has the Supreme Court also held the 311 is there for the courts not to be a mere bystander, but to ensure that the best evidence is brought on record. And if due to any inadvertence an evidence has not been brought on record, if it is required for the interest of justice, it can be brought on record, Millard. Now, Millard, then again, section 91 is explained. Now, Millard, comes to the facts of the case, Millard, wherein this court held in paragraph 42, how it has applied section 311, Millard. That the relevance of the decoding register was sought to be again added as an evidence, Millard. The relevance of the decoding register clearly emerges from the above statement of PW 41. Hence, the effort of the prosecution to produce the decoding register, which is crucial and vital piece of evidence, ought not to have been obstructed. In terms of the provisions of section 311, summoning of a witness for the purpose of producing the decoding register was essential for the just decision of the case. Having dealt with the satisfaction of the requirement under 311, we deal with the objections of the respondents that the application should not have been allowed as it will lead to filling up of the lacuna of the prosecution's case. However, even the said reason cannot be an absolute bar. Millard kindly notes this, Millard. However, even the said reason cannot be an absolute bar to allowing an application under 311. Millard, the Supreme Court has held that even if it appears to the court that a lacuna is being filled, that is also not an absolute bar to not allowing 311, Millard. Then Millard, placing paragraph 44 in the decision of Zahira Habibullah Sheikh versus State of Gujarat, which was more recently reiterated in Gujarat Pacific Tech Limited versus Computer Joint India Limited. The court specifically dealt with the objection and observed that the resultant filling up of the loopholes on account of allowing an application under 311 is merely a subsidiary factor, and the court's determination of the application should only be based on the test of the essentiality of the evidence. It noted that the court is not empowered under the provisions of the court to compel either the prosecution or the defense to examine any particular witness or witnesses on their side. This must be left to the parties. But in weighing the evidence, the court can take note of the fact that the best available evidence has not been given and can be drawn and can draw an adverse inference. The court will often have to depend on the intercepted allegations made by the parties or on inconclusive inferences from the facts elicited in the evidence. In such cases, the court has to act under the second part of the section. Sometimes the examination of a witness as directed by the court may result in what is thought to be filling up of loopholes. This is purely a subsidiary factor and cannot be taken into account. Whether the new evidence is essential or not must of course depends on the facts of each case and has to be determined by the presiding judge. The right of the accused to a fair trial is constitutionally protected under Article 21. However, in this judgment, it was reiterated in Rajendra Prasad that the court observed that it is the duty of the criminal court to allow the prosecution to correct an error in the interest of justice. Therefore, Rajendra Prasad was quoted, lacuna in the prosecution must be understood as the inherent weakness or the latent wedge in the matrix of the prosecution case. The advantage of it should normally go to the accused in the trial of the case, but an oversight in the management of the prosecution cannot be treated as an irreplaceable lacuna. No party in a trial can be foreclosed for correcting errors. If proper evidence was not adduced at a relevant material, or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified. After all, the function of a criminal court is administration of justice. And will kindly note this, paragraph 45, it's also marked in bold by the Supreme Court, in the judgment, Huh? That's it. I'll place this again. After all, the function of the criminal court is administration of criminal justice and not to count errors committed by the parties and to find out and declare who among the parties performed better. So this was the observation of the court. Thereafter, the case is again discussed. I'll just relying on last three paragraphs, 49, 50, and 51, wherein the Supreme Court has clearly summed up everything. This court is vested with a broad and a wholesome power in terms of section 311 of the CRPC to summon and examine or recall or re-examine any material witness at any stage. And paragraph 49,
Yes, I've seen. I've gone through. Already gone through paragraph 49, 50, 51.
Therefore,
Yes.
may permitted to place the matter.
Yes, I'm sorry I could not be there. Your Lordship has seen, in fact, the last paragraph of the last judgment is very succinct in its purport. It says that if there is a latent wedge in the prosecution's case, maybe the court, in the interest of for providing a fair and a level field, may not permit that. But mere failure in proper management of the process of trial, and if essential evidence has not been brought on record due to error, then the courts would be magnanimous in permitting it to be brought on record through 311. Well, here is not a case where it was never there on record. It was there on record. It was mentioned in the petition of complaint. Well, due to, I would say, error on the part of our counsel to bring it on record, this error happened. But would this be a ground to say no, it cannot be now brought on record? Well, with great respect, that is for that purpose 311 has been.
Service of ATM notice, they have filed that complaint before the
Yes, I'm deeply obliged.
That is the question that probably court can also invoke the power under section 165 of the Evidence Act. Because clicking my brain all the time. 165, production of the document, court can invoke the power under section even 165 for asking the party
Evidence
to
Act,
produce the document.
Evidence
To produce the document which was not served, which is required for the purpose of adjudication.
no problem.
For the
160,
purpose of adjudication. Proper adjudication of the issue.
162.
165.
May, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases. Production of any document. Yes, I'm deeply obliged to your Lordship.
Is actually, it was a question before the court. Yeah, whether it is revealed from the cross-examination of the witness that notice was served. Now, one question may arise before the court. If you serve the notice, what is your service document? Receipt. What is the receipt? Produce the receipt.
Yes, yes.
That was ought to have been asked by the court to the party. Produce the document. You have stated in cross-examination that I have served WTA. What is that document?
Well, perhaps
Court can have
remembers.
in exercise
Well,
power under section 165.
Yes,
Court can ask.
definitely, definitely. Well,
Usually,
your lordship perhaps
any
remembers the Zaira Habibullah's case, Gujarat Bakery.
Hmm.
The court, the learned judge is not a referee
Hmm.
who sits silent, but is to be an active participant in the.
Standby, not standby. Here also.
Well, so these are my humble submissions. Your lordship will kindly consider the same and kindly allows the application and permits us to produce those documents. He has always a right of cross-examination, and therefore it's not that he is completely divested of his rights. Deep. Yes.
Lord, if I may just begin where your lordship just left, that the court ought to have put a question to the witness. Lordship,
Question, I'm not talking about question, sir. I'm only talking about production of documents. I didn't question. There is some proviso clause. I'm talking about production of document under
Yes.
section 165. I'm not talking about the question, putting question. Any question can put,
yes, yes,
but he has to keep in mind the proviso clause. That I
certainly,
know.
certainly.
I'm not talking about production, putting question to the witness.
But if I may just go a step further, lordship knows that the court has its power to put questions on its own to the witnesses. Lordship, in my humble submission, even if the court would have put this question to this witness, she would not have been in a position to answer this. Lordship may kindly
Absolutely.
Lordship may kindly come to the cross-examination of this witness at
Cross-examination of?
this sole witness. Lordship may kindly come to page 85. Although my learned senior friend has placed the entirety of the complaint, the merits of the case, although the issue here is very limited, the very last line, page 85.
Page 85. Yes.
The sole witness that has been examined on behalf of SEBI. I do not have any personal knowledge about the contents of the complaint petition. What else is she going to depose about?
85.
Now, lordship may kindly note the date at the very top, 22nd of March, 2022.
Right. Yes.
On that very same page. This cross-examination is taking place on 22nd of March, 2022. Now, in the middle portion, which my learned senior friend has already placed, I have not filed any documents to show that the accused persons have been served with the SEBI orders. Not a fact that no notice have been served by us on the accused persons. This is our specific defense case. The certified copy or the original of the SEBI order has not been filed along with the complaint petition before the court. So it is a matter of record that the WTM order itself is not an exhibit in this case. Now, this is a specific question that was put. Now, lordship may kindly come to their application under section 311 at page. It starts from page 95. Lordship may straight away come to page 96. What they are actually seeking to bring on record. Page 96. If I may just read, paragraph 3. That on scrutiny, it is detected that due to inadvertence, the prosecution could not brought and or produce in court, lordship may now mark, the postal track reports, as well as receipts of communication of WTM order. They are not seeking to bring the WTM order on record.
Hmm.
They are only seeking to bring on record the receipts and the postal track reports.
Hmm.
As well as receipts of communication of WTM order to the accused persons on record, which is undisputedly a material documents of this case. Then the very next paragraph, that the postal track reports as well as receipts of the communication to the accused persons of the WTM order. This has been indicated in bold.
Hmm.
They have nowhere indicated that they want to bring the WTM order itself on record.
Hmm.
That the postal, I am repeating once again, Lordship, that the postal track reports as well as receipts of communication to the accused persons of the WTM order are material documents, which is essential for just decision of the case. So only they are seeking to bring on record the receipts and the postal track reports and nothing more.
Hmm.
This is the scope of the 311 petition.
Hmm.
With deepest respect, contrary to what has been submitted by my learned senior friend. And lastly, Lordship may kindly come to the prayer portion at page 97. Under the above facts and circumstances, it is humbly prayed that the prosecution may be permitted to recall PL Leena Shri, that is the PW1, or rather the only prosecution witness, to bring the postal track reports and receipts of communication of WTM order. The WTM order itself is not an exhibit, and they are still not willing to bring that on record.
Hmm.
Now, the learned court below, while rejecting their application, has made certain observations. If I may just take your Lordship to that, Lordship may kindly come to the certified copy once after 97.
Yes. Next.
Lordship may kindly come to the certified copy, the impugned order. It starts after page 97,
Hmm.
the second page of the impugned order.
Hmm.
If
Yes.
I may just take your Lordship to the findings once again. The paragraph starts with upon hearing both sides.
Hmm.
Upon hearing both sides and upon perusal of the materials on record, I find that though the prosecution has stated that these documents are very much needed and vital for arriving at a just decision in this case, yet no such document has been annexed to the petition by the prosecution, and neither have copies of the said documents being served on the defense prior to adducing of evidence.
Hmm.
As has rightly been observed, when process was issued, when they filed this complaint, this document was not on record. And Lordship, they have annexed the entire evidence. Lordship will find this WTM order is not an exhibit. In the petition under section 311 also, they have not prayed to bring that document on record. And neither have copies of the said documents being served on the defense prior to adducing of evidence or even argument of this case. If these documents were indeed vital to the prosecution, then the said documents should have accompanied the complaint petition and copy should have been given to the defense. Now, Lordship will find from the first observation of the learned court below that even when they filed this application under 311, they did not annex these documents. This
So
postal,
does it mean that court ought to have exercised power under section 165 Evidence Act? There is averments in the
there are
complaint.
averments. There are
averments. The notice was served. Naturally, one question will arise in the mind of the court that what is that document? First, produce the document.
Lordship, in my humble submission, the defense has put that document and the complainant has replied that I have no documents to show. And that answer was given in 2022. Lordship may kindly come at
to show.
Yes.
No, we have served the document.
No. Lordship may kindly come to
Where?
page
80.
Page 85. I have not filed any documents to show that.
Document. Yes.
Yes.
Not, I have no document to show, and I have not
Lordship, with
filed any
deepest of
document
respect,
to
the
show.
owners, the
Heaven and hell different. I have no document to show, and I have I have not filed to
yes,
file the document to show. These two words, two sentences are
very well, very well. Lordship, let us accept as it is. Let us accept as it is. Now, Lordship, kindly comes to the impugned order once again. May I place my lord? Now, if these documents were indeed vital to the prosecution, then the said documents should have accompanied the complaint petition and copies should have been given to the defense. From the evidence of PW1, I find that the PW1 has merely mentioned that such documents have not been filed before the court, but no explanation has been given for non-filing of the same. There is only a vague mention that notices have been served on the defense. Now, and lastly, Lordship kindly sees the learned court below exercises its discretion going through the entire facts and circumstances as above. I do not find any cogent ground for which the prosecution may be allowed to bring the said documents before the court at this stage. In fact, the entire matter appears to be an afterthought of the prosecution. Now, why this observation has come into effect? On 22nd of March 2022, evidence, rather on 23rd of, I'm sorry, my lord, on 29th of March 2022, cross-examination was completed. Lordship will find that at page 88. Now,
It was 29th March.
yes. On 20th of June 2022, SEBI filed a petition before the learned court below.
Yes. What is this? The prosecution submits they are not willing to produce any witnesses or any documentary evidence further as such. Evidence may be closed today.
Right, my lord? Now, pursuant to the filing of this petition,
Yes.
the evidence was closed. I'm just handing over the copy. Yes. Correct.
We don't do that. Done.
5th of September 2022.
No, it is over.
Or rather 20th of June, on that day itself. On that day itself, Lordship may kindly have a look at this order.
That was closed.
Yes. As per the prayer of SEBI.
PW1, there is prosecution evidence closed on 20th June.
20th of June 2022, on the very date when they filed this application.
Yes.
I've handed over the order sheet.
Yes.
And the next date was fixed on 3rd of August for 3:30.
Yes.
Now, Lordship, kindly sees how many dates have gone by in the meantime.
311, when it was filed?
It was their application.
Hmm.
Their application on 20th of June 2022, and evidence was closed on 20th of June itself,
20th June,
2022,
on the same date.
on the same day. That was heard, and application, their evidence was closed.
Oh, the. It's on the same day.
Yes.
So two applications were filed on the same days. One is
Only one application on behalf of SEBI.
one is not. One is not
To bring any further evidence and
further
not documents on
and
record.
Another is 311.
No, 311 has been filed subsequently.
When?
311 in the year 2023.
9th of February 2023.
9th of February.
It's at page 97 bottom.
That has been annexed with the petition.
Yes.
What I'm trying to place before your lordship is that on 22nd of March, the PW1, the defense had put these specific questions to PW1. Do you have documents to show? I have not filed these documents that they have received the WTM order. 22nd of March 2022, or rather 23rd of March 2022, evidence was closed on 29th of March 2022. They themselves filed this their application on 20th of June 2022. We do not intend to produce any further witness. We do not intend to file any further documents. As per their prayer, it has been categorically recorded in the order of the learned court below. As per their prayer, evidence is closed, and the trial proceeded to the stage of 313. Now, lordship, kindly have a look at the receipts which they intend to bring on record. Kindly comes to page 63. The postal receipts. Oh, before that, if I may just take your lordship to paragraph paragraph 6 of the revisional application at page 9.
Page 9.
Page 9 of the main revisional application, paragraph 6.
Yes.
May I place my?
Yes.
Your petitioner states that the order dated 24th August 2015, passed by the whole-time member of SEBI, had been duly served upon all the opposite parties. Now, lordship kindly notes, through hand delivery and affixture, and at all times they were aware about the said order being passed against them. Now, these annexures are annexure C. They start from page 63 onwards.
Page
63 onwards. I'm taking your lordship through these documents just to show
63. Yes.
that what kind of evidence they are trying to lead at this stage. Page, my lord, is at page 63? Yes. Name of the person, Pradip Acharya, one of the accused. Lordship, may kindly note the address, Manoshpara, Habra, North 24 Parganas, pin code such and such. Further, that now lordship may kindly come a bit lower down the page. Further, that the affixing at the above premises has been witnessed by the following persons, requested but refused. At the very bottom, lordship may kindly see what is the remark. Ei pada ekhane nei. So where was it affixed then? At the argument stage, this is the kind of evidence SEBI is trying to bring on record.
No kind of evidence. Evidence. This revision application at the time of considering the 311, there is hardly any scope to evaluate the evidence or documents. Only it has to be seen whether to fill up lacuna. You have mentioned.
Now,
many
Lordship,
things. You
now
have
Lordship will
mentioned
see that
many
they did
things.
not annex all these documents while filing the 311 application. These documents are now before your Lordship.
Huh.
Your Lordship is being called upon to decide whether these documents should be permitted to be adduced at this stage when arguments are about to commence.
Hmm.
When they had the opportunity to bring those documents on record more than a year back, when they have themselves said that we don't want to bring any further evidence, when they have themselves said we don't want to bring any further documents on record. Now, these are the quality of evidence which they are trying to bring on record. Cases of 2017. Lordship may have also come to page 65. These are notices which appear to have been received by hand. Page 65, page 66, and page 67. At the very bottom, Lordship will find received, the name is written in Bengali. Page 65 of the main revisional application. Is there any date mentioned, Lordship? Perhaps not. No date has been mentioned. SEBI is investigating an offense which involves such a substantial sum of money. And at this stage, they are intending to bring on record these documents.
No, there is no date.
No date.
Under signature of?
The first one is Jutika Mondal, appears to be the mother of this Dibakar Mondal.
That is her duty. She didn't put any date.
In none of the notices. In none of the notices.
Where it is top of the letter. Top of the letter there is date August 24, 2015.
Lordship, the issue is the main subject matter of the 311 is whether they have received, whether the issuance of the notice is one thing, Lordship.
Sir, there is enough scope to argue on these issues, whether these documents can be relied upon, whether the notice was actually served. You already gave a suggestion to the witness that no notice was served upon the accused. So you can raise this issue at the time of even admission of the document and at the time of argument also. This issue regarding documents as well as service, we have enough opportunity to raise all this issue before the trial court. At the time of even admission of the document, raises objection. Then at the time of argument, you can.
But Lordship, from the face of these documents, it appears.
My only point before this court as to whether they are going to disclose this document to fill up the lacuna.
In my humble submission, there could not be a more clear case where there could not be a more clear instance where SEBI is trying to fill up a lacuna. We are at the stage of commencing the arguments in the learned court below.
This is not the part at any point of it.
No, that is true. That is why I intended to take your Lordship.
Last stage.
That is undoubtedly true. That is undoubtedly true. Court may invoke this power at any stage, but that is the reason why I took your Lordships to these documents. What is the kind of evidence which are trying to bring on record when they had the opportunity to bring these documents on record more than a year back? At page 68 also Lordship will find same thing. এই ঠিকানা এখানে নেই স্থানীয়দের মত অনুযায়ী. Kindly comes to page 68 once. We are facing this agony since 2017, Lordship. One of the accused persons has expired.
60.
Page 68 at the very bottom. Premises number is mentioned. 94/1, ঠিকানাটা এখানে নেই স্থানীয়দের মত অনুযায়ী. And in the revisional application, they have claimed that those have been affixed. So where have these notices been affixed?
Hmm.
Address is incorrect. I'm relying on their documents only.
Okay.
So Lordship has seen from their documents only, they are seeking to re-examine PW1, who has herself stated that she does not have any personal knowledge about the contents of the complaint. They are seeking to recall PW1, who is going to prove service of these kind of notices, where the address on the face of it appears to be incorrect. Other notices do not bear the date. And this is a clear case of filling up the lacunae, in my humble submission. And the learned trial court has rightly exercised its discretion.
Yes.
Because learned trial court has also had the opportunity to take note of the demeanor of the witness also. Lordship may kindly note, it has been observed in the impugned order, there is only a vague mention that notices have been served on the defense. And now, when your Lordship kindly sees that the notices which have been, which they claim to have been affixed, this fortifies the fact they may not have been served.
Yes.
And Lordship, now after 6 years, more than 6 years, arguments are about to commence, and now these documents are allowed to be brought on record, the accused persons will be seriously prejudiced. And Lordship, my humble submission is that my learned senior friend has relied upon certain judgments, if I may be allowed to distinguish those on a
The one
later date.
reply, Mr. Ganguly, I want to hear you on certain points that is regarding notice. He has mentioned page 67, no date, 68, এখানে থাকে না,
Well, kindly takes up 68.
68. 68. Yeah? 63, 64, 68. Yes.
Kindly sees name of the person affixing the notice at the top. Shumon Maiti.
Shuman Maiti, name.
This name of the entity, this page 68 goes on. This is to state that the undersigned has affixed the order number of WTM dated in the matter of A addressed to the company petition at the above mentioned premises. And what is the above mentioned premises? Waris Plaza, 94/1, Ashoknagar, this. Who is saying that this does not exist? And who is he? He is not the person who is affixing it. 94/1 ঠিকানাটা এখানে নেই, স্থানীয়দের মত অনুযায়ী. This is being said by Manos Pradhan. He may be a local and he is not saying that 94/1 does not exist. স্থানীয়দের মত অনুযায়ী, hearsay. Sushant, this Shumon Maiti says I have annexed it. And he then kindly sees page 67, 68.
67.
68.
68 I've seen.
66, 67, your Lordship has seen.
Hmm.
These two are in respect of the other two accused persons, Debashish Chatterjee and Polly Chatterjee, received by their daughter. The notices are dated August 24th, 2015.
Hmm.
Now kindly sees thereafter page 65, the previous page.
Hmm.
Another accused, Dibakar Mondal, has been served
Not yet.
Jyotika Mandal.
by the mother, through the mother.
Hmm.
The other one, my lord, he again is at page 63.
Hmm.
Who is affixing that? Shumon Maiti. And who says ekhane ei para ekhane nei Torun De? He is no one. Further, and your lordship towards the middle, further that the affixing at the above premises have been witnessed by the following persons, requested but refused. What can a person do? তুই কি জাজমেন্টের ব্যাপারে কিছু স্যার সেটা যথেষ্ট একটু বল, তাহলে আমি তারপরে তো রিপ্লাই দেবো পুরো।
Not.
And as has rightly fallen from your lordship, what would be the ultimate probative value of these documents is something for the judicial discretion. But the question is whether these documents should at all be brought
Another
before the court.
question is raised that in your application under section 311, you did not seek any permission to produce the notice itself, that is WTM notice, order, WTM order.
Yes, that is there.
You only sought for on the track report, service return of the
My lord, I am making that prayer before this honorable court.
No, I'm objecting to that, lordship.
Then I again have to go back and do it. What would be the benefit in that, my lord? Kindly consider.
Lordship, now
Without the WTM order, the documents relating to service of the,
which document was served.
yes.
Next question will arise.
Huh.
Service track, which document?
So then
was
again, I have to go
So
back and file an
after-
application. It would be a mere wastage of time.
no, so that is a separate issue
No,
altogether.
that is not a separate
That is
issue.
a separate issue.
We are here in the interest of justice. My lord, under 482, in the interest of justice, for the interest of justice, your lordship can exercise that powers.
So in that event, lordship, in exercise of 482 can also prima facie look into those documents annexed at page 63 through 68. Who else? If this Shumon Maiti, if he's the person going to affix those documents at a public place, who else is he going to supposed to ask? The local persons only? And the documents at page 63 and page 68, do they give a prima facie indication, even a prima facie indication whatsoever that those documents have actually been affixed? এই
Yes.
ঠিকানাটা এখানে নেই, এই পাড়াটা
No,
এখানে
no,
নেই,
my lord,
what difference does it
my
make?
learned friend is perhaps not correct from the documents.
Lordship, may kindly see.
This is to state that the undersigned has affixed the order number this of WTM
এই পাড়াটা এখানে
addressed to the company. That is being said
the
by
locals.
someone.
This is the version of locals.
What local,
witnesses.
whether he is a local or not is to be
Even in
found
case
out.
of case of police cases also, lordship knows in where a seizure takes place, recovery takes place, independent witnesses, local witnesses, their evidentiary value is something else.
Yes, and usually hostile.
Not in all cases. And they are seeking to recall PW1 to prove these affixations. These have been affixed by Shumon Maiti.
He may know his signature. How does my learned presume that?
এটা না পিছনে
Lordship, may kindly
পিছনে না আপনি হ্যাঁ
my lord, if I may get another opportunity to distinguish the judgments which have been cited by Mr. Rao.
today will not be able
Lordship.
to
Just one more day, I'll finish it off. One more day, I'll finish it off. Kindly keeps it in the next week, barring 30th.
barring
30th, except 30th.
এই দেখুন how long will it take? 10 minutes, 15?
Three judgments, 20 minutes
In all, 20 minutes.
in all.
চলুন।
My lord, they have taken 10:30 to. I started around 12 o'clock.
I had a harder task.
Perhaps not. Perhaps not.
My lord, all I can say beyond this matter, the way the prosecution has been led by a government agency, it's very unfortunate, that's all. What can I say?
Forget it. Worst management.
And on a lighter note, if I may just submit, Lordship, while allotting time to me on the next day, may kindly consider the uphill task which I am facing.
Hey, কবে দেবে?
আরে লয়ারের 20 মিনিট মানেই 40 মিনিট হবে
30th বাদ দিয়ে except 30th. 31st?
31st, yes.
ফ্রাইডে আমি ডিপ 60 much
31st?
deep
31st Thursday.
Prepare for accommodation at both sides. At both sides. At both sides. Prayer for accommodation.
Last week of August.
On prayer for accommodation. What is the matter on 31st August?
Lordship may kindly keep that petition and the order sheet which I have handed over. Lordship may kindly retain it with us.
All the documents will. দরকার নেই ওটা সবই আছে তো কেস লাও লিখতে হবে
I am grateful for the patient here. Deeply obliged.
Item number 5.
To appear on behalf of the petition.
5 assign
And may I start with the case. My lord, 5 depicts a very sorry state of affairs, I must tell your lordship. My lord, the sessions judge cancelled the interim bail of the accused persons when it was already infructuous, given that was an interlocutory order. A final order or the bail was already confirmed by then. That also on the consent of the public prosecutor before the learned CMM Calcutta. All conditions were complied. Sessions judge, overlooking everything on the basis of an infructuous application, passes an order. Against that, my lord, I come before your lordships. On 13th of July, the matter is taken up by a coordinate bench. My lord directs that my lord just wanted to see the CD once and placed it for hearing on 19th of this month, my lord. 13th, this application was moved. I had prayed for stay of the operation of the warrant of arrest, which was so issued. My lord was of the opinion, since the order was passed long back and nothing happened, so within these 4 or 5 days,
so there is the date fixed positively.
so my
What is
lord,
the order impugned
my lord,
dated?
my lord, order impugned is 2/6/2023, my lord.
2/6.
2/6/2023. Passed by the learned sessions judge or chief judge, Calcutta, Bicharpur.
2/6. 2/6.
I will see the certified copy at the end, my lord.
This is an application.
My lord, page 30. Sorry, my lord, page 30 also. 17.5. My lord, very sorry, 17.5/20.
Sir, order is 17.
75. Very sorry, my lord. I just very sorry, my lord, very sorry.
Learned magistrate granted Ehlers accused on bail.
My lord. My lord, may I just take your lordship through the entire facts of the case? If my lord permits me, 5 minutes time only.
Factory was found with the firearms were being manufactured.
My lord, sees which is the impugned order before the learned sessions judge.
Then even learned magistrate further observed an investigation is almost complete standstill. Serious informative with the threat of within 1 week the factory The remain stands for it is domain industry in the case where the manufactured exception is found Bihar. Investigation is completed in the Christian belt. That is deprecated considering the nature of civil. Yes.
Yes. Well, may I just
Who is
take-
appearing on behalf of the state?
may I just take your lordships to the facts of the case. My lord, I have prepared a very short written notes for your lordship. Easier for your lordship. Also. Sure. दूसरा copy देना है, दूसरा copy दे दो। No, my lord, since the list of dates, no, the FIR was lodged on 22nd of March 2022.
Hmm.
STF apprehended certain persons or two persons from a spot in Calcutta. Now, my lord, the petitioners are not named in the FIR. Thereafter, my lord, in the course of investigation, they were arrested, these two present petitioners, on 2/4/2022, my lord. Now, petitioners were arrested from Jharkhand, so they were on transit remand and produced before the learned CMM on the 4th of April 2022, my lord. Then, my lord, on 4th, they were remanded to PC. On 11th, they were again remanded to further PC, my lord. On 13th, they were remanded to JC till 27th of April 2022. On 27th, my lord, the petitioners were remanded to JC till 2/5/2022. My lord, this is the order of interim bail which was granted by the learned CMM. Now, my lord, this order, my lord, would find at page 25 of the application, my lord, that interim bail payer of the petitioners were granted on condition that they were supposed to meet the IO twice a week. Now, my lord, on 13/6/2022, now, my lord, would kindly have the child to come to page 26 for a moment. 27 is the relevant portion. My lord, of the main application.
Yes. 27.
27 is the relevant portion. Heard learned advocate pray for confirmation of interim bail and waiving the condition of the same on behalf of accused persons such and such. And in this regard, petitions have been filed on the grounds stated therein. Heard both sides, perused the petition. The learned public prosecutor raised no objection for confirmation of interim bail and waiving of the condition in respect of the said accused persons. No adverse report is put up. Considering all such aspects, the AI bail of the said accused persons, number 1 to 7, that is within the petitioners included, are hereby confirmed and conditions are also waived. So, my lord has seen what is the order of confirmation of bail. Now, my lord would kindly take up, my lord, the last portion of the certified copy, my lord. which is annexed to the or enclosed to the application, revisional application, my lord. At the end, the application filed by the state agency is also there.
Hmm?
My lord, at the end, my lord,
At
they have
the
filed
end
the,
of- At the end of,
the certified copy, my lord. The application filed by the state, my lord.
Hmm.
My lord sees,
filed by the state for cancellation of bail.
my lord.
Hmm.
An application for cancellation of bail under section 439(2) against the impugned order, my lord sees the date of the order.
Hmm.
2/5/2022 passed by the learned CMM at Kolkata. My lord, this order with deepest humility and in terms of the settled law is an infructuous application, my lord. This order did not exist on the day this was filed. My lord, sees right top corner, my lord. It was filed on 26/8/2022.
39(2), yes.
My lord, AI bail was granted in May
Huh.
by a well-reasoned order.
Against impugned order dated 2nd May,
My lord,
interim order.
AI bail order.
Hmm.
It was confirmed on consent.
Hmm.
PP did not raise any demur or objection.
Hmm.
He says that I have scrupulously attended all conditions.
Hmm.
They did not raise any dispute.
Hmm.
In fact, the learned public prosecutor, who was a helm of affairs and was duly instructed, appraised the court that we have been
Whether
scrupulous.
instructed or not, that I don't know, my lord.
Let
Let him not say that duly
it be
instructed.
recorded that the learned PP is
Yes,
not
yes, yes.
instructed.
I'm recording. My lord can record my submission.
Absolutely, my lord.
What
A
was the
litigant must
submission
not
of the
suffer.
public prosecutor doesn't reflect
Well,
that the investigating officer was also present, and as per the investigating officer, the public prosecutor has stated.
my lord, let it be recorded
What-
then, my lord, in that case. They should have brought it to the notice of the court.
Raised.
Public prosecutor, the learned CMM, says the Honorable High Court's public prosecutor cannot say that he was not instructed. If he is submitting without instruction, first that has to be brought to the notice of the higher forum. What they do is they suppress that order. As they said before your lordship today, that he was not instructed, he did not have. If he did not have the instruction, he could not have said that he has complied with the conditions and we do not object to it. And what they do is, in the month of August, they file an application suppressing that the order had already merged into a final order and this order did not exist at all. On the basis of such infructuous application, the matter was pursued by the state agency without bringing it to the court's notice that this order or the application itself was infructuous.
That has already been confirmed in the
Subsequently confirmed, which was never challenged before the
by
learned
the order
sessions court.
dated 13/6.
By the order dated, my lord,
13/6.
13/6, I bow down before your lordship. That to my lord on consent. It is not that they objected. I've taken your lordship to that ordering portion as well, my lord, at page 27.
Interim. Yes.
It will.
Yes.
Now, my lord, I've made a short notes for your lordship, my lord. On 27th of February next year, that is 2023, my lord, the charge sheet also came to be filed in this matter, my lord. So investigation also was complete.
Charge sheet when filed?
27th of February 2023, my lord. 2023, my lord.
No, date.
27th February, my lord. 27 to 2023, my lord.
Hmm.
Now, my lord, about 3 months thereafter, my lord, that is exactly about 1 year after the date of confirmation of bail, my lord, 17/5/2023, the learned sessions judge rejects the, my lord, allows the cancellation application, cancelling the bail of not, my lord, of the confirmed bail, of the bail which never existed on that date. I would kindly have the charity to come to page 30 for a moment. That is the impugned order. Or page 30.
Page?
30, my lord. Page, running page 30 of my page, my lord. Application, my lord, is the impugned order.
Impugned order?
Page 30.
Yes, I've got it certified copy also.
My lord. My lord, sees 1, 2, 3.
17th May.
17th May, my lord. 5th line. The what was challenged and what was considered. The impugned order dated 2/5/2022 is challenged by filing this criminal miscellaneous case wherein the learned trial court observed that it appears that substantial portion of the investigation is already complete and the accused persons are in custody for a considerable period of time. It also appears from the CD is stagnant without any remarkable development since 25/4/2022, and the investigation has almost come to a standstill. Considering all these aspects, I do not think further custodial detention of the accused persons is going to serve any useful purpose for investigation. So, my lord, what was there before the learned judge on the date of the cancellation application also, my lord, is that interlocutory order which never existed on this date. Now, my lord, may I go further? This is a case under 25 1B A of Arms Act, read with 120B of the IPC Act and 25/8/35 of the Arms Act. This case is sessions triable in nature, and the learned magistrate committed serious error in the matter of grant of bail only on the ground that the accused person are in custody for a considerable period of time. The learned magistrate also observed that the CD is stagnant without any remarkable development since 25/4/2022 till 2/5/2022, and the investigation is almost complete, has almost come to a standstill, and according to the learned magistrate, further custodial detention of the accused person are not necessary for any useful purpose of investigation. First is, hello? So, my lord, he cancels the bail on 2 grounds. 1, on merits, saying that this is a grave offense. Second, holding that the learned magistrate did not have the power to grant bail in a case involving 25/8 or 35 of the Arms Act. My lord, with deepest humility, my lord, first thing, my lord, merits, I am not commenting on that. Second portion, my lord, this notion that he did not have the power to grant bail is perhaps erroneous. But there is no embargo. It speaks of there being an embargo in 437, which speaks of it has to be sessions triable and the punishment has to be life or death. Now, my lord, any interpretation which takes away that if it is only life, 25/8 has life. If it is only life, my lord, that will curtail the right of a forum. And perhaps, my lord, that cannot be the proper interpretation. There are different judgments which say that it has to be the alternative punishment has to be there, like in death, rape, dacoity, that both are there, sessions triable, or my lord, both of them have to be there. Only if it is life or it is sessions triable, or maybe 2 out of them 3, like say 409 or 467 or whatever, or 402 for that matter, there's no embargo. And the magistrate had duly appraised his mind and had passed an order. So there cannot be legal bar on the learned magistrate. Factually, things might be different. That, my lord, the learned sessions judge could have appraised. He might have his own opinion on things. But on the point of law, my lord, perhaps he could not have said that the learned magistrate was functus officio to even deal with an application which involves 25(8). My lord, effectively, if that notion is taken, then, my lord, the very purpose of filing bail applications, or, my lord, the learned magistrate sending a person to remand without having the luxury or the capacity to grant bail will lead to a fallacy, my lord, which nobody can address. So closing the door on the learned magistrate by a judicial order saying that, no, you don't have any power is perhaps a very wrong interpretation of law. There is no complete bar. Only in cases where either or both are there in an alternative, like rape, dacoity, murder, that the learned magistrate still then has the power for women, sick or infirm, and in cases where he has other beliefs. So that also is there. So there cannot be a complete bar to the learned magistrate's power. That way it will lead to an absurdity of law. Now, may I just take your lordship to the
Now, where it is written that learned magistrate has no
My
power
lord.
to grant bail
my lord, there, my lord, is there. I'll show you, lordship.
in the order into
My lord. It is there. My lord. Firstly, my lord, 1, 2. My lord, after learned magistrate, CD also observed, learned magistrate also observed CD is stagnant. My lord, middle of
this is a case under
first it is the case, fact was found with.
this is
As a sessions tribal case,
uh,
learned magistrate should not have ventured upon the same.
that doesn't mean it's a bar.
My lord, that
That doesn't mean magistrate has no power to grant.
my lord, he says, learned sessions
Not
judge says,
venture.
my lord, he can always
That
venture.
doesn't necessarily mean it's a bar, statutory bar to grant bail. 37, magistrate has power. Magistrate has power if it comes with the proviso.
My lord,
Absolutely has power.
my lord.
However, it is the observation of the learned the session judge, chief judge, that should not
Venture.
venture.
My lord, the learned
This
session
all-
judge can say that he should be more cautious or should. But it cannot be said he cannot venture into sessions tribal cases.
Mhm.
Venturing means he does not have the power. There's a fetter.
It is also reiterated by the Honorable Apex Court. I cannot recollect the exact citation.
My lord.
In that case also, sessions tribal case, in all sessions tribal case, magistrate
Should be
should not
cautious.
venture. Should not venture. This word was
Well,
written
now
by the
that-
Honorable Apex Court also in a case I can recollect right now. The probably in
Maybe
the
in
year
Bafna.
2001, 2002, 2003. Probably within these 3 years, Honorable Apex Court opined the same.
Well, yes, my lord, now that the
Line-
law has been
The
crystallized,
same line that should not venture in sessions tribal cases.
my lord, now my lord,
However, it is not a bar.
my lord. Well, now Satinder
Observation
Kumar
of
Antil
the
is also
learned
there.
session judge, it is cannot be construed that it is a bar. Magistrate cannot entertain any bail application. This is not a bar, function of bar. He only societal impact,
My
he
lord.
only
Deeply
focused on societal impact. This is a manufacturing,
My lord.
arms manufacturing factory was assaulted, so societal impact, he thought that bail ought not to have been granted to the accused. This was his observation.
My lord. But this is
Not, this cannot be said that absolutely erroneous.
my lord.
It cannot be said.
But he uses the term
You can
cannot
assail
venture.
this order. You can assail this order in terms of dates. The actually interim order cancelled, but that order was further confirmed by the subsequent order, probably
13-6, my lord.
2022.
My lord.
What about?
My
This
lord.
is the
And
point
the-
of law. Mr. Nandi will
My
clear.
lord. May I just
That
take your
is-
lordship to the short written notes that I've prepared for your lordship? My lord, first point, if my lord takes it up, is the merger of interim order.
Merger of,
Interim order.
yes, merger of interim order that is confirmed by the order dated
My-
13/6.
Now, my lord, would kindly take the, well, I have relied on certain
Did you
judgments.
serve the
My lord, I have this. My lord, at the end, my lord, kindly takes up the judgment as cited in support of the same. That is of Premchandra Agarwal and another 2009 11 SCC 479, my lord.
Yes.
My lord sees, I have just written very short judgments because my lord, this is settled law. My lord, it is well, my lord, paragraph 3. It is well settled principle that once a final order is passed, all the earlier interim orders merge into the final order and the interim orders cease to exist.
Where, which paragraph?
My lord,
Oh.
paragraph 3, my lord.
Paragraph 3.
3, my lord, 6. Premchandra Agarwal. But it is well settled principle that once a final order is passed, all earlier interim orders merge into the final order and the interim orders cease to exist. In this appeal, since the final order has already been passed by the High Court, obviously all interim orders passed by the High Court in the same writ petition cease to exist automatically. Consequentially, and then, my lord, the appeal has become infructuous and is accordingly dismissed. Then, my lord, the next page, may I take your lordship? My lord, the next page. Very short order of this honorable court in CRM DB 310 of 2023. Recent order passed by the honorable division bench. It is contended on behalf of the petitioner that the opposite party number 2 was granted interim bail without considering the case diary. Sridhar articles have not been recovered. We note that the order is an interlocutory order. Petitioner had cooperated with the investigation. Plea with regard to non-recovery of Sridhar articles may be agitated at the time of confirmation of bail in accordance with law. Hence, we dispose the application giving leave to the petitioner to file application for cancellation of bail before the learned magistrate, and in event such prayer is made, the same shall be considered expeditiously. But here also, the honorable court, then my lord, the next page also, have just annexed few orders of this honorable court to show that this has been a consistent view. My lord, next page, my lord. Is another order where my lord had delivered this order. My lord. The state seeks cancellation of interim bail. But similar, my lord. State has sought for cancellation of interim bail granted by the jurisdictional court with the order such and such. Public prosecutor submits that there are various issues impugning the order granting interim bail. He highlights that the fact that the accused subsequently granted interim bail is absconding. We are of the view that since jurisdictional court is yet to dispose of the application for grant of bail finally and granted interim bail upon the accused video order to such and such, which was extended from time to time, it would be appropriate to request the jurisdictional court to dispose of the application for grant of bail as expeditiously as possible. All points raised by the parties are kept open to the decide.
Next.
Next order. Petitioner has challenged ad interim order of bail. We are informed that ad interim order has since been confirmed. Application for cancellation is rendered infructuous. My lord sees 1754. Same thing. Before High Court, by that time, it has become infructuous. Next order, same my lord of a different coordinate bench, my lord division bench, says the same thing. That it was confirmed. However, it has become infructuous. You cannot challenge an earlier order which does not exist.
Mr. Nandi,
My lord,
what about
But-
interim order? You have challenged the interim order only.
that, my lord, I have seen.